This lecture is a part of a series entitled Using Judicial Review to Promote Access to Justice for All. It's been organized by the CARIBONO Network, the Faculty of Law, the UWI Mona, MonaLaw, and the Faculty of Law, the UWI Rights Advocacy Project, URAP. In this presentation, UK Queen's Counsel Phillippa Kaufmann discusses the use of strategic litigation as a mechanism for challenging violence against women and girls. She reviews several cases in which she was involved as a barrister that sought to promote justice for women and girls who have been the victims of violence. Her review includes cases involving the notorious rapist, John Worboys.
Right, good afternoon, everyone, and thank you for coming, and thank you to Arif and Tracy and CARIBONO and the other bodies involved in organizing this series for inviting me to be part of it, not least because I tend to learn a great deal at these sessions and I depend upon the training which Arif and Tracy put on so that I can continue my regional professional development. I think my primary qualification for the role of moderator in this afternoon's session is that I'm from the region and I'm a barrister with a keen interest in equality and human rights. On the other hand, the person I'm about to introduce, the keynote presenter, Ms. Phillippa Kaufmann, her expertise and her suitability to this task is incapable of being overstated. In some ways, when I was planning this introduction, I knew, of course, that I knew Ms. Kaufmann quite well, and she wasn't any stranger to me, being a friend and colleague, a former colleague. But I was pleased to learn when I satisfied my positive obligation to conduct an effective investigation of her Westlaw entries. And I discovered something that I hadn't quite appreciated, even as an old friend, that she is no stranger to the region, and her name may perhaps be known to some of you here today. I haven't reminded her of the full breadth of her Caribbean expertise because it allows me to have one up on her in our fierce competition to decide which of us is likely to be suffering from early onset cognitive impairment. But she has a number of cases. And indeed, there are a few directory accolades about Ms. Kaufmann that I must tell you about, as I've not ever heard them said of, I've not heard them said of any or many other advocates. One is that she's one of the best lawyers of her generation. She has a high octane brain, whatever that means, and is a blistering advocate. And as she's known to me, I know exactly what's meant by at least two of those, high octane brain and the blistering advocate. Her Caribbean practice, I'll tell you a little bit about that and then pass you straight over to her. She hasn't been partial in the way she has worked in the Caribbean. She has represented, or in Caribbean matters, I should say, she's represented a dazzling and representative array of persons in Caribbean cases. She's acted for governments, public institutions, individuals, including proverbial treasonous insurgents. Those of you, all of the Caribbean, I'm sure, is fairly familiar with the 1994 case of the Attorney General of Trinidad and Tobago and Lennox Phillip, where Ms. Kaufmann represented as a junior one of the participants in the 1990 coup attempt in the government's appeal to the Privy Council to confirm the lawfulness of its decision to arrest and detain Mr. Phillip. So that was one of the areas in which she represented an insurgent, so to speak. Then there was a series of appeals in murder and capital murder cases in which she acted concerning Jamaica and Trinidad and Tobago. There was a prisoners' rights case of significance, Mollison, in which she, led by Edward Fitzgerald QC, also known to the jurisdiction, persuaded the Privy Council that provisions in the Juveniles Act 1951, which allowed the Governor General to substitute detention at his pleasure with life imprisonment, was contrary to constitutional provisions which should ensure that deprivations of liberty should be by way of a sentence or order of the court and not by the executive. In 2004, I thought I should mention, she even tried to invoke the jurisdiction of the Privy Council where none existed. And in that case, she was trying to prevent the extradition of a, get this, Russian from St. Kitts charged with selling stable isotopes in Canada. Now, I wasn't aware that there was a prohibition against selling stable isotopes, but perhaps Phillippa can tell us later on in the post-talk line. Anyway, so Phillippa has a wide-ranging practice which has involved a number of cases involving the Caribbean. And of course, she has also been involved in a case of some significance in terms of colonial era wrongs, and that's Mature and the Foreign and Commonwealth Office, where she secured an unprecedented damages for torture of Kenyan detainees in the context of the Mau Mau rebellion between 1952 and 1960. And I suspect that this is jurisprudentially very, very important for claims against ex-imperial powers. So there we have it. Judging from Ms. Kaufmann's Westlaw entries, I would say that we could say that when she wasn't litigating about issues important to the Caribbean or relevant to the Caribbean and colonial and state authorized or authored harm or on behalf of prisoners or victims of the coercive apparatus of the state, she was involved in the kind of litigation to which she'll be speaking today. And that is strategic litigation challenging violence against women and girls. I happen to know that much of her recent working life has been absorbed by the cases that she's going to discuss. She'll speak about the challenges to systemic failures by the police in relation to various allegations, criminal allegations, and of course, about decisions to prosecute. And she'll be looking not so much as the details of the cases, but how issues were tackled in strategic litigation and in public law using the instruments that we have in the UK. So it is a pleasure to introduce Phillippa Kaufmann to you all, and I hope that this session is as enriching as we all hope it to be. Thank you.
Thanks so much, you lady. You did see me, although I was on mute, I was laughing through most of that, hysterically, really. So Eulalie and I actually are very, very close friends. We've been incredibly close friends for 30 years now, having become close friends when we shared a house together. And I've never heard her speak so nicely about me before in my life. I must do this more often. Anyway, I also want to say thank you so much for inviting me to participate in today's part of the series that you are all putting on. I think it's an absolutely superb project, and I am genuinely really honoured to be able to just bring to the table some of my own experiences. I thought it would just be useful for me to talk about some of the cases I've done, the different issues they've thrown up, and the different ways in which you can seek, depending on what arises, obviously for each of you in your jurisdictions, but the different ways in which you can seek to use public law or constitutional law to try and advance the rights of women and to bring an end to gender-based violence. So if I've got time, I'm going to talk about 5 cases, I think, and if I haven't got time, I'll just have to stop. But we, I think, are going to provide you with all the case reports, all the law reports, so you can go off and read them at your leisure. So it's a bit of a whirlwind tour, and I'm obviously not going to go into great detail about the legal ins and outs, but hopefully just give you some sort of overarching sense. So the first 2 cases I'm going to talk about are both arise from something that happened on the streets of London between, well, we now know, probably between about 2000 and 2008. And this was a series of rapes by a London taxi driver called John Worboys. And John Worboys owned one of London's signature black cabs. And using the opportunities it gave him as a cab driver, he preyed upon lone women who at night would get into his cab, quite often after a night out, young women after a night out, a little bit tipsy, and he managed, through a very, very particular modus operandi that he developed over time, to drug them, stupefy them, and unquestionably rape them. I had two clients who I represented who were victims of his. And the first one was a victim who was attacked in May of 2003. And the second one was, we believed at the time, his 75th victim, and she was attacked in July of 2007, so 4 years later. And both of them reported their cases to the police, and the police investigated both of those cases, and the police did the most appalling job in investigating them, with the result, obviously, that from May 2003, following that useless investigation, Worboys was free to continue. And even after July 2007, when they actually had Worboys on camera and got his, as he dropped my second client off, NBV, they had his number plate and they actually interviewed him, they still didn't arrest him, and he went on to commit 29 further offences before he was eventually caught in the beginning of 2008. Now, the sorts of failings were not failings of policy, because the MPS had some fantastic policies in relation to the investigation of rape. And they even had policies specifically targeted at drug facilitated rapes, which Worboys was. And these were incredibly detailed and set out very clearly how investigators should go about investigating. And the problem was in the application of those policies, or the non-application of the policies. And there are a number of explanations, but one of the explanations for why things were as terrible as they were in each of my clients' investigation was this total disbelief on the part of the police that a black cab driver, a London black cabbie, could possibly rape anybody. So they had this view in their mind that if you're a taxi driver in London driving a black cab, you just are a decent, honourable guy. So that was problem number one. And the second problem was the women, because the women were in a terrible, terrible state. My first client was in such a bad state after she had consumed a drink at the behest of Worboys in his cab. And these were the early days as he was beginning to work out his modus operandi. But at that point in time, I think he told her he'd won something and asked her to celebrate with him. And he had spiked her drink, and he managed to spike the drinks later on with a cocktail which had the most extraordinary effect. And at this point in time, he spiked her drink with a cocktail which I'm not quite sure what it contained, but definitely contained an antidepressant as well as all sorts of other things. Anyway, the result was, by the time she gets dropped off at her home, she's forgotten, in fact, that she's moved down the road. She's recently got married and had a child, and she'd moved from one house to another on the same street a few doors down. She's so stupefied that she thinks she gives him the address of the place she used to live at. She's dropped off there, and this stranger opens the door, the new occupant, and he finds her full of vomit in the back of the cab, completely unconscious. And he insists on accompanying her to the police station where she's dropped off, and then she's taken off to the police station. So when the police hear all about this, her state is one where they again assume that she's just gone out and got too drunk and you know, nothing has happened to her whatsoever. And they fail to undertake very, very basic investigative steps. For example, they never interview that guy. They never follow up and look at the route that she went and travelled down, because she was able to recall having gone off that route, which is where the attack then happened. But they never look at the CCTV footage. They never question people who were with her at the time that she was put in the cab to look at the state she was in. They fail almost completely to undertake any steps, with the result that they don't identify him and catch him. And he goes on to commit all these other offences. And similarly, in 2007, when NBV is herself attacked, as I mentioned, they have CCTV footage of him being dropped off at her university halls of residence. And she stumbles out and he helps her out, and something drops, which is very probably a tampon, a sanitary towel that's dislodged after his attack on her. That's all visible, but she's stumbling and he hugs her and she hugs him back. And so the police again start with this attitude that she has just engaged in some sort of, voluntary encounter with this guy. And that is the starting point, even though she tells them she is supposed to have gone to work at 9 o'clock that morning, didn't wake up till 4 in the afternoon, has no recollection, as is the same with the first victim, of anything that happened from the moment that she took that drink. And what the police did in relation to her was to knock on his door to ask him to come for an interview. He wasn't there, so they just left a message asking him to come to the police station for an interview. Lost the opportunity, therefore, to take him by surprise, to search his car, to search his house. And when he came for a police interview, they effectively simply apologised to him in the course of the interview without identifying the numerous ways or following up on the numerous ways in which his account simply didn't tally either with the CCTV footage they had or with the account given by the complainant. So the long and the short of it was that by January of 2008, he had committed over 100 offences, it was believed at the time. So these women desperately wanted to do something about this. Obviously to vindicate their own rights, but more importantly, to ensure a step change in the attitude and the approach of the police to investigating offences of rape. And in England, there is, and I'm not sure whether this is the case in the Caribbean, I suspect it is, but there is there was at the time, it was characterised as an immunity from suit on the part of the police in claims of negligence. So we had to look at another vehicle to try and hold them to account. And that was the first claim that I'm going to talk to you about. And this was a claim which was based upon the Human Rights Act and the domestication of the European Convention of Human Rights into English law through the vehicle of the Human Rights Act, and through the right not to be subjected to torture or inhuman or degrading treatment or punishment under Article 3. And we were able to trace a developing jurisprudence in Strasbourg in the European Court itself. So taking that negative obligation not to subject, and this is an obligation on the state, not to subject anyone to torture or inhuman or degrading treatment or punishment, which rape obviously is, and to trace the development of a number of positive obligations that the court had read into Article 3. So they started the European Court from the position that you, as a state, are obliged to secure these rights to your citizens, the right not to be subjected to torture or inhuman or degrading treatment or punishment, and that has implications not just in respect of the actions of the state and state agents, but also in relation to the actions of private persons and citizens. So one citizen against another. So for example, this resulted in the identification of a positive obligation to pass laws criminalising conduct which is incompatible with the prohibition on torture, inhuman or degrading treatment or punishment. And obviously the prescription of rape as a criminal offence meets that obligation. But they went beyond that and they said that you need to, as well as putting in such laws prescribing such treatment, you need to then put in place state machinery to enforce those laws, so a police system. And then they moved beyond that and said you actually have to then ensure that that machinery operates effectively in practice. So that machinery, which requires a police service, has to then engage in conducting effective investigations when the police have notice of a credible allegation on the part of a private citizen that they've been subjected to treatment that's incompatible, such as rape. And so we relied upon all of this jurisprudence to bring a claim And we did it under the Human Rights Act by way of a private law claim, because judicial review, so under the Human Rights Act, you can either go by judicial review or you can bring a private law claim. And it was plainly for us much better to bring a private law claim, because we had to establish as a matter of fact the failures to conduct an effective investigation, and we needed to be able to cross-examine witnesses in order to be able to do so. And so we brought a private law claim and had a 1-week trial where it wasn't exactly difficult to establish that there had been failures to conduct an effective investigation. We then also had to establish that as a matter of English law, through the Human Rights Act, that positive obligation had been domesticated, and we had a massive fight on our hands to establish that, which went all the way up to the Supreme Court, and eventually the Supreme Court said, yes, there is in English law a duty to conduct an effective investigation. And in the cases that we will give to you, there is the judgment, I think, of the Supreme Court, but also the first instance judgment is well worth reading by, as he then was, Mr. Justice Green. It's a real tour de force, looking at all the European Court jurisprudence. And what he said about the positive obligation, or what the Strasbourg authorities say about it. What is the nature of an effective investigation? What does it oblige a state to do? Well, firstly, it's an obligation of means, not result. So it doesn't have to result in a conviction. It's about the process of going through and investigating whether or not there has been a criminal offence. So the authorities are obliged to take the reasonable steps available to them to secure the evidence concerning the alleged crime, including, for example, getting eyewitness testimony, getting forensic evidence, and where appropriate, an autopsy, which provides a complete and accurate record of the injury or an objective analysis of the clinical findings. Any deficiency which undermines the investigation's ability to establish the cause of death. I'm taking this quote actually from a case which is about Article 2. What I should say is there is no difference if somebody dies as a consequence of a criminal offence, or somebody is subjected to inhuman or degrading treatment or torture, or somebody is trafficked into slavery, contrary to Article 4. All these fundamental rights under the European Convention on Human Rights carry the same positive obligation to conduct an effective investigation. So any deficiency which undermines the ability of the investigation to establish the crime or the person responsible for the crime or the persons responsible risks falling foul of that standard. Now, our courts are very clear that it's not any deficiency. It's serious deficiencies which are fundamental to the investigation, without which the ability of the investigation to establish sufficient evidence, or the necessary evidence, is capable of constituting a failure to conduct an effective investigation. So that was the first case, and we succeeded in that, and we got the judgment in that case after waiting for a year in the Supreme Court, almost at the same moment where we then heard that John Worboys was going to be released from prison. So what happened after Worboys was finally caught in the beginning of 2008, and I should say that it wasn't down to the police finally getting their act together that he was finally caught. It was actually down to an incredible woman who had seen the second victim when she made the allegation of rape, the doctor who had seen her to carry out a forensic examination, putting 2 and 2 together and bringing her case to the attention of the police. But when finally his case was brought to the attention of the police then did really get their act together and seek to investigate the offences. And he was ultimately put away. And he was put away on the basis of a number of sample charges. And what they did is the prosecution effectively took the strongest charges. And what that meant ultimately was that they prosecuted him for the more recent offences to the time of his prosecution. and he received what was called a sentence of indefinite detention for public protection. So what that meant was a bit like a life sentence, a discretionary life sentence. He was given a punitive period for his sentence, and then he was not able to get out of prison until he had satisfied the Independent Parole Board that he no longer presented an unacceptable risk to the public. So what happened on his very, very first hearing before the Parole Board, after he'd served that punishment period, even though he was held in the highest security categorisation within the prison estate, he was a Category A prisoner, which is in England and Wales, Category A prisoners are prisoners for whom escape must be made impossible because of the danger they pose. So despite that categorisation, the Parole Board deemed it sufficiently, he had reduced his risk sufficiently that it was safe to release him. And when that was announced, there was a serious public outcry. And as you can imagine, my clients were just in such a state, just a state of complete disbelief that this could possibly have happened. So there was a massive public outcry, and the question then became, well, what, if anything, could be done about it? Now, parole board proceedings in England are ones which are conducted with the parole board as the decision maker, the prisoner on one side, and the Secretary of State for Justice sitting on the other side, effectively advocating for the prisoner generally to stay in prison, not always. And in this instance, the Secretary of State had advocated for him to stay in prison. So we sat back for a while because of questions of standing and in judicial review, and waited to see if the Secretary of State would bring a judicial review in the face of the public outcry. And for reasons that I still don't understand, the Secretary of State eventually decided he wasn't going to bring a judicial review. And so we, on behalf of the two women, their solicitor and myself, who represented them in the case against the police, we mounted a judicial review of the Parole Board's decision. And we did so not knowing anything about the decision, because at the time, Parole Board decisions were entirely secret. So we just ran this argument that it was irrational in the face of what we did know, which was that he had been classified as a Category A prisoner, that he had committed all these offences. We just submitted it was completely perverse to have concluded at this stage that he could possibly be deemed sufficiently safe now and sufficiently changed to be released. And we argued that we had standing because we were his victims. And if we didn't have standing, then nobody had standing. And so there were two issues for the court: who had standing to bring this, and then what was one to do in a situation where at the moment we knew nothing. So happily, there was no objection actually on the part of Worboys to permission being granted. And the consequence of that was that we did then get all the Parole Board documents, and there was a lot of preparation that had to be made to redact the various parts of the documents, but we got everything. I should also add that the Mayor of London, who was also concerned on behalf of the women of London, also sought to bring a judicial review alongside us. And so we challenged both the decision to release him, but also the secrecy surrounding the decision. And that secrecy was something that was mandated by the Parole Board rules. And we argue that those rules were ultra vires and contrary to Article 10 of the European Convention on Human Rights and Freedom of Expression is Article 10. And we said that it was contrary to freedom of expression for that decision to be given wholly in secret. The consequence of getting all that material was that we were able to see that what Worboys had said to persuade the Parole Board that he was no longer dangerous was completely inconsistent with his history of offending, albeit not with his conviction. So I mentioned that when he was prosecuted. He was only prosecuted for the offences running at the end of his spree of offending. So he was prosecuted for a span of offences running over about a year and a half. But we knew, of course, that he had started offending much, much earlier, and DSD was believed to be one of his first victims, and she was attacked in 2003, and his first conviction was for an offence committed in 2006. And the account he gave of why he had committed his offences all related to the breakdown of his relationship with his partner in 2006. So incapable of explaining how he was offending back in 2003. And so there were a number of legal issues, but our case was that the Parole Board and the Secretary of State were sufficiently on notice, albeit he was only convicted of offences running from 2006, that they were sufficiently on notice that he had committed many, 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 many other offences, and had done so at a time which was completely incompatible with his explanation for why he'd offended, and therefore threw complete doubt into his alleged change, and threw obviously into sharp relief the question of whether he was being deeply, deeply manipulative. And so the question was whether or not the Parole Board's decision was irrational in the face of the evidence and the material that it had available to it, and whether it was material which it was required to take into account on rationality grounds, i.e. it was so obviously material that it was irrational not to take it into account. And that was the basis. So it was a traditional Wednesbury challenge, and that was the basis upon which we ran the case. That was the basis upon which we succeeded. So we were given standing, the court said we had standing, and ultimately quashed the decision, and he was not released. So the consequence of that decision was that he was kept in prison. The veil of secrecy was also lifted in relation to Parole Board proceedings, and summaries are now provided, particularly to the victims. And the further result was that the Crown Prosecution Service then got their act together, and Worboys was prosecuted for further offences going right back to I think 2000 or 2001. So they found more victims, and they found that he had offended even earlier than we had believed to be the case. And he was convicted of further offences, which resulted in him receiving 2 life sentences. So he remains in prison, and he is now, there will be no question that any future Parole Board decisions will be based upon the full span of his offending. There were some very bad consequences for prisoners, because the Parole Board became incredibly cautious because of the public furore, and they started looking at criminal allegations rather than criminal convictions in so many cases, because one of the issues in this case was, is the Parole Board entitled to go beyond the convictions and look at allegations only? And we established that, yes, it was entitled to do so. Well, the consequence was that the Parole Board started doing that all the time, which had massive implications for delay, but also the Parole Board became very, very nervous and cautious in its decision making. It also resulted in the resignation of the chair of the Parole Board, which was forced on him by the Secretary of State for Justice, who did that basically because he wanted to hide from his own responsibility, because actually the task of putting the material before the Parole Board that would have disclosed all these further allegations was that of the Secretary of State, and he didn't discharge that task. So I'm now going to go on very quickly then to talk about End Violence Against Women, EVOR, and the Director of Public Prosecutions. Now, this was a case that we brought earlier this year. I brought together with an organisation called the Centre for Women's Justice, which is a charity which brings strategic litigation in relation to violence against women. And we brought it on behalf of an NGO called EVOR, end violence against women. And this was a very, very ambitious challenge to a number of actions on the part of the Director of Public Prosecutions. And it arose out of the precipitous drop that took place at the end of 2016 into 2017 in both the volume of rape cases being prosecuted and the rate of prosecutions of rape. I mean, the most enormous drop. So the volume of cases charged fell by 52%, and the charging rate fell from 56% to, at its lowest, 29%. So there was this massive drop off, and this came after a 10-year programme on the part of the CPS to really try and turn around its approach to prosecuting rapes. And it had done an absolutely brilliant job, and the numbers had gone up, the rate of convictions had gone up, and it had all been done on the basis of something that was called the merits-based approach. And the merits-based approach was contrasted with the bookmakers approach. So what prosecutors were told to do is that you've got to put yourself in the position of an objective decision maker, or an objective jury rather, and ask yourself whether or not that jury is more likely than not to convict on the basis of the evidence. Now, what that means is you have to push aside stereotypes and prejudices that jurors very often bring to bear, particularly in relation to women, particularly in relation to rape cases. And there was a huge amount of training that went on, and the guidance in support of the evidential test in the code was very extensive, and all of it referred to this merits-based approach in contradistinction to the bookmakers approach. And the bookmakers approach is simply, you just look at what a jury is more likely than not to do, as a matter of fact, not what it should do if it's acting reasonably and objectively. So what then happened in 2016 and 2017 is a new director of legal services came in. He carried out a number of reviews of the statistics within a number of prosecuting areas, and noticed that in some areas, when it came to contested trials, so not cases where the defendant was pleading guilty, but cases which were contested, which are always, of course, the much more difficult cases, the charging rates weren't as good as he would want them to be, and in his view you would expect them to be if that objective test were met. And so he concluded, on the basis of that and on the basis of one report that he was provided with, that there was a real and substantial problem in prosecutors misapplying the merits-based approach and effectively just going with a victim's account and not testing it in any way, not seeking corroboration in any way. And therefore, he decided he was going to do a series of things. The first of which was to conduct a number of road shows in which he went around to all the prosecutors, rape prosecutors in the country, and he trained them away from the merits-based approach, in the sense that he told them not to refer to the merits-based approach anymore. And he emphasized conviction rates, and he emphasized that we ought to be getting more convictions than acquittals. He introduced a conviction rate of 60%, and later, after that, he removed from all training material any reference to the merits-based approach. Now, it's important to say that the merits-based approach is simply a description of the way in which the Code for Crown Prosecutors sets out the evidential test. So the evidential test as set out in the Code for Crown Prosecutors is the merits-based approach. It requires an objective approach, putting aside stereotypes and so forth. But our concern was that actually what he had done had sown so much confusion and so much caution that it had actually resulted in a change in practice. And whether that change in practice was to lead prosecutors wrongly to actually start applying the merits, the bookmaker's approach, or whether the change in practice was to make them so cautious that they weren't actually honouring the merits-based approach, was neither here nor there for us. Our concern was that what he had done had precipitated this massive drop. So how on earth do we go about challenging that? I mean, it wasn't easy, because it's very difficult to characterise those actions as typical decisions in relation to judicial review. So we did it by characterising what he had done as a change to policy, which arose from the removal of the reference to the merits-based approach, even though there was no substantive change, as it were, to the test for the evidential test. We also challenged the training and the manner in which the training had moved or encouraged prosecutors to move in the way that they were taking their decisions. And we also challenged the introduction of the 60% target. And in order really to give ourselves a platform, we instructed a statistician, because the DPP comes along and he says, well, actually, this precipitous drop is nothing to do with, I mean, it may coincide temporarily may coincide temporarily with the, sorry, you ladies just told me to hurry up, so I got put off. I will move on in a sec. It may coincide temporarily with the precipitous drop, with the training. The precipitous drop might coincide with that, but it's actually due to all sorts of other things. And so we instructed a statistician, a wonderful woman from Oxford, who's an economist, to look at all the statistics and to look at all the explanations offered by the DPP as to what could account for this precipitous drop, and to test it against the statistics. And similarly, to take the training and the change to the guidance and the introduction of the targets, and to test whether or not that was consistent with the drop. So the question was consistency, not causation. And she came back and she said, the changes and the explanations put forward by the DPP cannot explain that drop, but his actions that were the subject of our challenge can explain the drop. So we felt that this was a very, very powerful starting point to then bring a challenge based upon public law grounds. So we argued that it was irrational. We argued that it was unlawful because the change in policy or the change in practice created a risk of illegality. So it was a systemic illegality challenge, which is a sort of developing ground of judicial review, which has recently received a bit of a knock on the head from our Supreme Court. And we also brought a challenge on grounds of failure to consult. But what we obviously had to show and satisfy the court was that there was some substantive consequence here, or a very, very great risk of a substantive consequence to the actions that he had taken. And I'm afraid I haven't got a lot of time. I haven't got any time, in fact, to really go into this. But it was a very unusual judicial review because we had an enormous amount of disclosure. And we were able to and did analyse that disclosure to really test his reasoning and his decision making and what had led to the decision to take these very drastic steps. And it was thin. It was so thin. I mean, the judgment when you read it is it doesn't unsurprisingly do justice. We lost, and it doesn't do justice at all to the incredible work that the team, and particularly my juniors, put into it in showing that effectively what had happened was a knee-jerk reaction based upon not liking the statistics, and there wasn't an attempt either to address what other explanations there might be for why the conviction rates were as they were, and there was a complete failure to also see whether or not the result of the recommendation of the body he relied upon, who had expressed some concern about the misapplication of the NBA, whether their recommendation that there be further training bore fruit. And our argument was that in light of the thinness of the evidence he relied upon, the obvious possibility that the recommendation might bear fruit, and the very grave risk he was taking, which he himself recognised, of oversteering, he should have waited and he should have looked at further evidence. We lost on that. We lost on failure to consult on the basis that, just as we'd lost on irrationality, the court decided there was actually no change. There was no substantive change at all. And they so decided because they concluded that the merits-based approach remained and hadn't changed at all because the full code test was the merits-based approach, i.e. completely failing to look at the underlying statistical evidence and simply sweeping it under the carpet. It was an incredibly disappointing result, but it was something that I think, you know, I remain incredibly proud that we brought the case. And what it did do is it highlighted, and this is a really important thing to think about in strategic litigation, is it highlighted the issue, it kept the issue in the news of what a terrible thing is happening in England and Wales in relation to the prosecution of rape. You know, how can we get to a point where there is a 29% charging rate in relation to rape cases? And that's 29% of cases that are brought to the attention of the CPS by the police for them to consider whether to charge, not 29% of all complaints. So moving on very quickly, next two cases arise from another scandal that happened in England. This all came to light in 2011. What we discovered in 2011 was that for about the last, well, we now understand it was about the last 50 years, a secret branch of the police has been infiltrating environmental movements. It all started during the Cold War, and they were at that time infiltrating Maoist organizations. But when that all stopped, they found new work, and they started infiltrating animal rights organizations, environmental organizations, and sending undercover officers in who pretended to be part of the movement, fellow protesters. And they stayed in these movements for up to 7 years, living a full life as an environmental protester. And I represented at that time 8 women who had all had long-term, well, many long-term, some shorter term, intimate sexual relationships with people that they later learned to be police officers all the time. And you can imagine how utterly devastating it was to discover that the person who was your soulmate, the love of your life, people who they were going to marry and settle down with, had actually been police officers spying on them the whole time. So we brought claims against the police in relation to all of that. And one of the claims we brought was a private law claim seeking damages for violations of the human rights of all those who were victims after the Human Rights Act came into force. And for those who were victims before, we just brought them on a standard tortious basis. And one of the issues in relation to those for whom we could rely on their human rights was that their undercover officers were acting pursuant to powers conferred under a piece of legislation called the Regulation of Investigatory Powers Act. And that act regulates all covert intelligence gathering tools, including covert human intelligence sources, which includes undercover police officers. And one of the problems is that the Act provides that any human rights claim has to be determined in a, I've got 5 minutes, okay, I'll be really quick. It's any Human Rights Act claim, any human rights claim has to be brought in the Investigatory Powers Tribunal, which is a secret tribunal. And none of the women wanted, obviously, for obvious reasons, to bring that case in a secret tribunal. So one of the ways in which we sought to argue our way out of that tribunal was to argue that the Act itself does not authorise police officers acting undercover to use sex and intercourse as an investigative tool. Now, if we were right on that, then that would bring us out of the jurisdiction of the Investigatory Powers Tribunal. So we ran that argument. I still can't believe we lost it. I still cannot believe that it is permissible under the way in which the authorizations are regulated under that statute, which is not tight regulation. It is permissible in some circumstances to authorize officers to have sex. But there you go. So that was one of the ways, again, in which we tried to use human rights. And there it was the right, obviously, Article 3, not to be subjected to inhuman and degrading treatment. Now, the other issue that came out of these cases was the case of Monica and the DPP. Monica was one of the victims. Monica complained to the police and she wanted her officer to be charged with rape. So the DPP refused to do so, arguing that it couldn't constitute rape because she had consented. So there we brought a judicial review, the aim of which was to challenge the way in which the DPP had interpreted the provisions relating to consent in the Sexual Offences Act. So it was used as a vehicle by which to try and update consent and the law on consent so that it reflects the way in which women do consent to sex and does not, as it currently does and continues to do, reflect a very male-centered gaze. So the question was, what sort of deceit vitiates consent? And the law effectively, as it was endorsed by the court in this case, because we lost, ties deceits in relation to the sexual act itself and the performance of the sexual act as ones which are capable of vitiating consent, or deceit as to identity in the sense that somebody impersonates another identifiable individual. But a deceit such as this, where you are presenting an entirely fictitious persona from beginning to end, is not a deceit that is capable of vitiating consent, which again, I still find absolutely remarkable. So that was another means by which we sought to challenge. And I think that's all then. I think that's all the cases. So sorry for that massively whirlwind tour, but I hope it's given you a flavour of the different ways in which you can use both constitutional law and judicial review to make these challenges.
Thank you very much for that. I've got a string of questions in the chat and others, but I think we're going to ask Dougie to come in now and make his erudite comments. That was really very interesting in a number of ways in terms of the use of public law and human rights instruments. But I'm going to ask Dougie to comment, and I'm told reliably by everyone that he needs no introduction. He's just the conscience of the Caribbean. So Dougie, there you go.
Thank you very much, Julie. Well, I'm going to comment, if that is the correct word, on just one aspect of Phillippa's presentation, and that is dealing with the litigation in the United Kingdom surrounding the failure of police officers to investigate sexual offences. And I will stretch it a bit to deal with the situation which we encounter here in Trinidad and Tobago, and I'm sure across the Caribbean, where victims of domestic violence have difficulties getting their cases heard swiftly in the courts. So those are the two aspects that I just want to address and really relate it to, or ask the question whether the jurisprudence in the United Kingdom can be translated in a Caribbean context. Now, I've written something so that I would make sure that I would stay within Tracy's requirement that I don't go above 10 minutes. And Tracy, I'm sure I'll be less than 10 minutes. So here goes. Fundamental rights and freedoms in the English-speaking Caribbean are primarily framed in language which envisage rights being infringed by positive action taken by state actors. They do not cover violations by private persons, so we cannot sue the perpetrator of domestic violence for a breach of a constitutional right. We have to look to the common law, to specific legislation providing remedies against domestic violence abusers. What the work of lawyers such as Phillippa brings to light, however, is the existence of constitutional remedies against the state, where the state actors fail in their duties to protect victims of domestic violence by not properly investigating or not prosecuting their domestic violence violators. It also raises the question whether there's a constitutional remedy where it is the court system itself which fails to accord the protection which is available under the law. Our fundamental rights and freedoms are also not expressed in such a way as to put a positive obligation on the state to take action to protect fundamental rights. Under the European Convention, there is a positive obligation in Article 1 to secure the right to everyone, the rights and freedoms of the Convention. And the right to life in Article 2 is itself expressed as a right to have one's life protected by law. However, we in the Caribbean have a fairly long tradition of interpreting our constitutional rights as placing an obligation on the state to take action to secure rights, as has been catalogued in the text on fundamentals of Caribbean constitutional law by Tracy, Arif, and Justice Saunders. Thus, Justice Barrow, who is now a CCJ judge, made it clear in the case of Francois against the Attorney General that a citizen's right to life and the security of the person created an entitlement to protection by the state against domestic violence, including by the enactment of appropriate protective legislation. As Tracy had commented in a piece she had done in a seminar, Justice Barrow rejected the claim that the St. Lucia Domestic Violence Act was unconstitutional, with the answer that on the contrary, it was constitutionally required. Another example is the decision of the Trinidad and Tobago Court of Appeal in Karim against the Attorney General, where it was held that the failure of the police to identify and arrest the person who killed the relatives of the claimants amounted to a breach of the right to protection of the law, because it prevented the claimants from seeking redress before the courts against the perpetrator. All of this, of course, is against the backdrop of clear rulings by the court and the commission in the inter-American system, that the failure by the state to prosecute a domestic violence abuser with alacrity violated a number of the rights protected by the Inter-American Convention. The violation may occur as a result of unreasonable delay by the police in launching an investigation and in laying charges against the perpetrator, or by the delays by the court in processing the charge and coming to a final decision. As the court said in the famous Maria de Pina case, I'm quoting, "The failure to prosecute and convict the perpetrator under these circumstances is an indication that the state condones the violence suffered by Maria de Pina. And this failure by the Brazilian courts to take action is exacerbating the direct consequences of the aggression by her ex-husband. Furthermore, that tolerance by the state organs is not limited to this case, rather it's a pattern. The condoning of this situation by the entire system only serves to perpetuate the psychological, social, and historical roots and factors." Close quotation. The Caribbean Court of Justice has now interpreted the right to the protection of the law as embracing a positive duty to take steps to protect fundamental rights and freedoms. This development has stretched over a number of years, beginning with a statement in the famous Joseph and Boyce case, that the right to the protection of the law covered much more than the protections spelled out in the constitutions to ensure a fair and open trial. It culminated in the decision of a unanimous court in the Maya Leaders Alliance case, where this passage occurs. It's a fairly long passage, but it's very important. Quote, the law is evidently in a state of evolution, but we make the following observations. The right to the protection of the law is a multidimensional, broad, and pervasive constitutional precept, grounded in fundamental notions of justice and the rule of law. The protection of the law prohibits acts of government which arbitrarily or unfairly deprive individuals of their basic constitutional rights to life, liberty, and property. It encompasses the right of every citizen of access to the courts and other judicial bodies established by law to prosecute and demand effective relief to remedy any breaches of their constitutional rights. However, the concept goes beyond such questions of access and includes the right of the citizen to be afforded adequate safeguards against irrationality, unreasonableness, fundamental unfairness, or arbitrary exercise of power. The right to the protection of the law may, in appropriate cases, require the relevant organs of the state to take positive action in order to secure and ensure the enjoyment of basic constitutional rights. In appropriate cases, the action or failure of the state may result in a breach of the right to the protection of the law. Now, the CCJ's approach has been adopted by the Privy Council in two cases, Maraj and the Prime Minister and the Commissioner of Prisons against CPASAD, both Trinidadian case, and the CPASAD case having been decided just a couple months ago, with the result that the CCJ's conception of the protection of the law is now the law right across the region. It is not difficult to translate the positive obligation to take action to uphold rights into a justiciable right to a remedy along the lines of the remedies and damages acknowledged by the UK Supreme Court, where due to serious operational error, the police failed to prosecute a domestic violence offender. More problematic may be the availability of a remedy where it is the court itself which fails to give a domestic violence victim a remedy provided by law. I'm not speaking here of a challenge to a decision by a judicial officer who rejects a claim based on its merits. There is in that case a right of appeal. I have in mind the denial of a prompt and effective remedy which occurs as a consequence of what can only be described as systematic, if not systemic delay in processing a domestic violence claim. In this regard, the Privy Council's summary of one aspect of the protection of the law jurisprudence in CPASAD is important. This is what they said. While the right to the individual's protection of the law is capable of being fulfilled by the availability of an efficacious and continuous remedy through judicial proceedings, a breach will arise where the remedy cannot be or is not provided. The cannot be scenario will typically arise in a case where the affected person has not initiated legal proceedings because no appropriate remedy is available. In contrast, the is not scenario will normally arise in a case where the person concerned has indeed pursued legal proceedings, in which event the focus will be on adverse outcome, or whether any remedy secured thereby was both prompt and efficacious. This declares to be viewed in the context of the even more recent decision of the Privy Council in Duncan against the Attorney General, where it was held to be a violation of the due process of law, where the Court of Appeal failed to consider whether it should exercise its discretion to deduct time served pending appeal in computing the remainder of a sentence to be served upon the dismissal of an appeal. That marks a significant departure from prior jurisprudence that the remedy in such a case was to appeal to a higher court. These developments, in my view, provide an ample basis for seeking constitutional remedies where the judicial system fails a domestic violence victim seeking redress. Where there is significant delay in processing a claim, it can justifiably be said that the right to the protection of the law is infringed, not because a remedy cannot be provided, but because it is not provided. So that's all I have to say. I hope I stayed within 10 minutes, Tracy. Thank you very much.
Thank you very much, Douglas, for that. And I'm going to, I think it seems to me to be sensible to just return to Phillippa to see what comment she has on those two things. I mean, I think as I see it, Douglas is indicating that he thinks the positive obligation issue may not be quite as much of a challenge in relation to executive action as perhaps we had thought in our earlier discussions, Phillippa, in the Caribbean, but that in relation to the conduct of the court and the securing of a remedy, that's the problem. And just your comments on that, please.
So, yeah, thanks so much, Dougie. I mean, that's so good to hear, because you know, I really had no idea what the status of positive obligations was here, but it does seem very much as though it is ripe here for the development of a jurisprudence that would both impose operational duties on the police to take protective measures in relation to women who are at risk of domestic violence, for example, whose lives are at risk or who are at risk of being seriously wounded. You know, if women come and complain, then if that positive obligation is capable of arising, then the police are then under a duty to, or one can argue and establish a duty on the police to take reasonable steps to protect those women through the police powers and the criminal process. And equally, a duty such as I described from the DSD case to investigate after offences have been committed. And the two run into each other, but they are distinct. But those duties would run right across from duties to protect life, obviously, right through to duties to safeguard women who are at risk of serious violence. So that's great to hear. In terms of the judiciary, is there no way in which one can simply, I mean, I don't know how it works here, but could you not? Because we can certainly, with the Human Rights Act, we can, because the court is itself a public authority, we can certainly rely upon human rights in proceedings before the court to say to the court, you yourself must act in this way because of the obligations that fall upon you as a public authority to safeguard the rights. So would it not be possible for you to appeal to the judiciary in a case and say, you are part of the state machinery subject to the constitutional duties or the rights and the corresponding duties that arise under the Constitution, and therefore one aspect of that is a duty. It's really the operational duty. I mean, through imposing orders. I assume you're talking about orders that will protect women, such as injunctions and so forth. That they are under a duty to exercise their powers speedily in order to protect those women's rights. I mean, that's certainly what would happen here.
Yeah, I mean, one of the two things are coming up in the chat, Phillippa. One is that Tracy is indicating that the Jamaican Charter of Rights excludes the judiciary as a relevant public authority subject to the Charter, and I suppose that's one issue that arises. And the other thing I was going to ask you is if you could briefly explain what operational duty means for the benefit of everyone here, because I mean, some of us, I mean, even I am only vaguely familiar, but some others may not be, especially those who work in domestic DV support.
Yes. So the operational duty is just like the duty to conduct an effective investigation. It is a duty that is cast upon, it's a positive obligation cast upon the state by reason of the three absolute rights that are guaranteed under the convention: the right to life, the right not to be subjected to torture and inhuman and degrading treatment, and the right not to be held in servitude or slavery. And all those three rights, and also the right to privacy to some extent, require states as part of their duty to secure the rights to their citizens, even in respect of the conduct of private persons, to take measures whenever they know or ought to know that somebody is at risk at the hands of a private person of being treated in a way that is incompatible with their fundamental rights, to take reasonable measures which are capable of protecting them and averting that treatment. So if you complain to the police, if you call the police as a victim of domestic violence, then that duty, that operational duty to take effective operational measures will be triggered.
Yeah.
And
sorry.
So again, it's again a way in which you can overcome some of the problems that have arisen in England from the police being incapable of being sued in negligence.
Yeah, I mean, that's key. I mean, one of the questions that came up as well, Phillippa, here, and I'm just spreading it out to this issue, is that position the same in the Commonwealth Caribbean? I mean, I think Tracy put it on the chat. I'm not sure how many others respond. Is there immunity from suit in negligence, as we might expect, because it's a common law jurisdiction, which is generally in accordance with what things we're familiar with in the UK? Is that right, Douglas or Rishi or anyone else?
I don't know the answer to that question directly. I've never really encountered it. I don't know if there are any practitioners who are online who would be able to answer that. But yeah, I'm not seeing anybody responding. But I suppose in essence, if it exists, then this is the route. This is the
and it's also an effective route because it means that you can, negligence is always backward looking, but this is a duty that is cast upon them that you can then seek to enforce. So you can organizations who are supporting women can appeal to the police and say, you are under this duty, you have to do this person's life is at risk, you need to take these measures in the here and now. Certainly things have moved on in the United Kingdom in relation to negligence, and it's now characterized really much more on the basis that there is no duty of care in respect of omissions to act, which is really what this is. So it's less now cast as an immunity from suit and sort of being recast as just simply a situation in which a duty of care doesn't arise and is incapable of arising.
Thank you. I mean, there are 3 or so more questions in the chat, if I can come in with that. The first, and I'm going to take them in no apparent order other than where my eyes alight at this point. And one of them is from Joshua, and he asks whether or not you could elaborate, this is for Phillippa, if you could elaborate further on the general position regarding the ground that a decision creates a risk of systemic illegality.
Yeah, well, I'm going to decline that invitation on the basis that we have just had a really, really unhelpful judgment on this. The jurisprudence was developing beautifully in England on systemic illegality, which was a principle that started really in relation to fairness. So if you had policies which, by reason of something inherent in those policies, it is liable to, it creates an unacceptable risk of individual decision makers who apply that policy making unlawful decisions, then the policy itself is unlawful. So what it was trying to target was aspects of a policy which by their nature and by something which inheres in them is liable to bring about that result, as opposed to the individual decision maker just making aberrant decisions of their own motion, as they always are capable of doing. So in relation to fairness, something about the policy that is going to lead to unfairness in individual decisions in some cases. So a lot of it arose in the context of immigration, where policies were established which set down very, very short timetables for asylum appeals to take place, for example, and where one was able to say, well, looking at the time table that is established in this, we can say that there will be some cases where the nature of the case is such that it is simply impossible for a fair decision to be made under that timetable. Then you can target the policy, because it is the policy that is inherently giving rise to that risk of illegality. And that's how the whole thing started. And there were a number of cases where that was broadened out to a policy, to any form of illegality which is liable to arise from the application of a policy. So it could include, for example, a policy that in its application is liable to result in a violation of somebody's human rights, for example. So there is no limitation of the illegality, the resulting illegality is a process one such as fairness. There has just been a decision of the Supreme Court called BF Eritrea. It is a decision 2021 UKSC 38, BF Eritrea and against the Secretary of State for the Home Department, where Reid, Lloyd-Jones, Briggs and Lord Sales and Lord Burnett have really narrowed down the utility of systemic illegality. And rather than talk about it, I just recommend that people read it. It's a real disappointment.
Well, I'm going to ask you then, Phillippa, to just answer a question asked by Roberta Clark. And Roberta, I understand you're on, and Tracy says you can reveal yourself for this question, so you can ask it yourself rather than me asking it for you. There we go. Yeah. Thank you, Roberta.
I mean, I'm quite happy with you asking it for me, really.
No, you go for it.
Good afternoon, everyone. Thanks for this seminar. I'm listening to the sort of, of course, our argument is that we want to use litigation more to sort of get to systemic failures. And the systemic failures are rather dramatic in all aspects of gender-based violence. So listening to Phillippa's presentation and the developing jurisprudence on the police duty to investigate, I mean, it's wonderful. We also have big attrition issues here in the Caribbean, as in many parts of the world. But I see from the UK reports that, in fact, notwithstanding the litigation, notwithstanding the elaboration of the duty to investigate, prosecutions and convictions for sexual violence in the UK are very low level, much like what we're experiencing here. So it does sort of raise the question about the investment in litigation. I mean, not for myself, but what would you say to a skeptic on this strategy?
So I think there is no question that the most enormous amount of damage has been done to the prosecution of rape. And I remain very, very, very firmly of the view that a large responsibility for that damage comes from the changes that we failed successfully to challenge. What is clear is that it is so bad that something has to be done about it. And so I do expect to see that change. I expect to see improvement. The litigation kept, as I said, the litigation really kept this issue on the public agenda, and it resulted in a government review looking at all aspects of the criminal justice system in relation to the prosecution of rape to try and understand what was precipitating this drop. I'm not saying they've got the answers, but and I'm certainly not saying that litigation is the only way to go. I think it is a tool in the armory. When we took it, we knew it would be very difficult. As we went on, we actually thought the case became very, very, very strong. As it was, we lost. But had we succeeded, then that would have, I think, had a dramatic effect in terms of altering the confidence of prosecutors, I think, as much as anything. We lost, but I remain of the view that it was a valuable thing to have taken it. And of course, sorry, yeah.
So the last small question for Douglas. A lot of the lawyers who do this work in domestic violence and perhaps even in some prosecutors do the sexual offenses, but let's say stick with the domestic violence, are doing it in the magistrate's court and doing it oftentimes within the context of family law. And they tell us, those of us who are working in services, that they don't have the public law experience. How do we, and someone who has been the Law Association president is a senior person in the profession, how can we encourage attorneys like the ones who are online to get involved and to take these cases on?
Well, that's a very good question. It's thankless work. As it is, the vast minority of persons who are coming into the profession prefer to do criminal-based work. So there are a very small number of lawyers in any event in that field, and they appear to be overworked. And from the stories I hear, it's very harrowing to have to face a court that is adjourning your case over and over and over again. That is something the Law Association will have to take up. The Law Association has started some outreach to lawyers in that regard, and of course there are the training sessions that Tracy had mentioned earlier on that the Law Association has been engaged in, trying to ensure that the lawyers are sufficiently skilled to deal with these matters. But the only thing you can offer really is to open your door for advice. If young lawyers need advice as to how to treat with the systemic failures of the judiciary, then they have to seek that advice from senior lawyers. And maybe what is needed is a test case where the failures of the magistracy or the masters to determine domestic violence applications swiftly is brought before the court for some sort of determination, so that they can all be aware that what they are doing when they adjourn matters interminably is violating people's constitutional rights. I think it is quite commonplace to have cases where you make an application for a protection order before the court. Phillippa and you, Lily, you may not know, we have a Domestic Violence Act that permits applications to be made to the court directly for protection orders. And so, but you make the protection order, which by its nature is urgent, and the application, even for an interim order, is adjourned for a number of different reasons. Many times the magistrate simply does not turn up, and the matter is adjourned indefinitely. And it's not unusual that a year passes by before the application for protection order is heard. In the meantime, if there is further domestic violence, the question must arise: is there a remedy against the state because the judiciary has failed to process the application within a reasonable period of time? I suppose, to answer Roberta's question directly, sessions like this hopefully will equip those lawyers who are doing domestic violence cases with the necessary tools to bring applications before the court. And they will also know that there's an organization such as CARIBONO, which exists, which is there to render assistance to young lawyers and not so young lawyers as well, who want to do this type of work, and to explore as much as possible what remedies are available to victims of domestic violence, but other victims generally.
Thank you, Douglas. I think we're coming to time now, so I'm going to close off, if I may, with two short questions for Phillippa as the key presenter and Douglas as the responder, so to speak. And I'll do it in reverse order, if I may. So, Douglas, I wanted to say to you, in a sense, what you just said. I presume there are huge funding hurdles with test case litigation in the Caribbean. And what's the funding situation in relation to that? Is it NGO funding? Is it crowdfunding? What is it?
No, we have legal aid.
Yeah.
It's not. It's not going to make you rich, but it is sufficient to keep younger lawyers going from month to month. Whether they will be minded, well, I know that the current chairman certainly is minded to assist in domestic violence cases and to expedite the necessary certificates so that there can be funding available. I don't see any reason why it can't be extended to these sorts of challenges as well, so that there is that available. There are some NGOs as well who engage in this type of work, provide some legal aid. I'm not too sure to what extent it is as vibrant as one would like. I think Roberta might be able to answer that better than I can.
Okay, I'll pick that up in a moment if I can. So turning lastly to you, Phillippa, I suppose what I wanted to ask you to close, to leave the seminar with in a way, is when we look at DSD and that sort of couple of cases that about the Parole Board and of course about the failure to investigate, I mean, you outlined what the changes in relation to Parole Board policy are, but have you been able to see the impact in the way you talked about in relation to what Roberta said, whereas even failed litigation had some impact in bringing the matter to within the public consciousness. But in relation to DSD, what are the changes in the process of police investigation that you've seen coming through, or the policies in relation to that? Have you been able to observe them?
I don't think I can answer that with any real depth of knowledge, because it's really about what goes on at the coalface, because the police are in England pretty well, certainly in the Metropolitan Police, pretty good at putting all the policies in place. It's about training people to apply those policies and you know, sufficiently resourcing the units that need to deal with that. And certainly you know, the evidence at the moment in relation to rape and the very, very low conviction rates in relation to rape and prosecution volumes in relation to rape, the explanation for that is not solely with the prosecutors. It's not solely decisions of
exactly.
It's also police investigations. And we know that they are terribly under-resourced, you know, in England as well. So, so I'm sure that the problems definitely still persist. But I also have no doubt that the fact that there are lawyers who are able to then bring actions, which cases like DSD have opened up, puts pressure on them. I mean, you know, they end up spending a lot of money defending these cases. So ultimately they have to put some investment. So I say that because, for example, in relation to DSD, one of the things that was happening was that the police force was putting lots and lots of money, not into the serious sexual offences unit, it was putting it into the car theft unit, because they could get, the money went much further. They could get, you know, much higher conviction rates there. That sort of thing, you know, might happen less often if they're subject to the threat of litigation.
Yeah, well, that's another useful thing to note in terms of the point of strategic litigation, even where it has low prospects of success or good ones. It just helps to keep that in the frame. Right. I think I think that's probably all we have time for today, isn't it, Tracy? And with that, I'd like to thank Phillippa and Douglas for really, really insightful and interesting contributions. I mean, all the way over here from in the UK, where I've known Phillippa for 30 years, I haven't understood the full context of DSD and the other cases like AJA until today. So that's useful for me. And I hope it helps those in the well, not necessarily Commonwealth, but Anglophone, Caribbean, who are on here, and others, to think about how it might work for them. And I'm heartened by what Douglas says in relation to positive obligations, and also, I mean, the fundamental rights that we see on the statute books and a lot of the constitutions we looked at in the lead up to today. Obviously, those negative rights have within them themselves positive obligations. So there's something there to work with, and I think that's what Douglas has identified. There's stuff to do on the issue of courts and looking at how one seeks a remedy in relation to the judiciary where they fail, but that, I suppose, is a task ahead. Anyway, thank you very much to everyone, in particular to Phillippa and Dougie, as I said, and to CARIBONO, to Tracy for the tireless work, to all of those who've attended, Arif, IT, everyone. Thank you very much.